Okay, well, I think people will just have to join us as we're started because I don't want to waste too much of everyone's time tonight. I see that our first presenter is ready to go. Hi, Jenny. And so we'll get started. Our first presenter is one of our supervising assistant prosecutors. Jenny Schucke is going to discuss adult and child sexual assault cases. Jenny, if you want to join us, do a little introduction. Let us know how long you've been with the office and kind of what your current position is.
Great. Good evening. I'm Jenny Schucke. I'm an assistant Sonoma County prosecutor under Sherry Bevan Walsh. I have been with her in this office for 21 years, which seems hard to believe at this point. But I have kind of grown up in the office, and now I work in the violent crime unit, and I'm one of the supervisors. So primarily I'm dealing with murder cases and sexual assault cases, and then helping to train younger prosecutors in their job. So my presentation, and I'll try to get up here and share my screen, is on child and adult sexual assault cases.
Oh, Jenny, you're going to run the PowerPoint, Jenny?
Yeah, is that okay?
Yay, Jenny, of course, it's fantastic. Thank you.
Oh, perfect. Okay. Makes it a little easier having here. Turn easier on you. Let me see if that works. Is that okay?
We see it. I'm good. I think I see it. I hope everybody else sees it.
Okay. All right. So yes. So child and adult sexual assault cases. I guess we start out with some statistics. Who are the victims? So I just actually updated my stats from previous years, and they've unfortunately gone up. 433 plus thousand Americans 12 years and older were sexually assaulted or raped last year. And sadly, again, 3 out of every 20 are kids. When we say kids, they say under age 12. So it's like, but for us at our job here, it's 12 and under, really. And I'll go into that in a little while. The law is different as it pertains to different ages of adult and child victims. 9 out of every 10 victims of rape are female. I guess you maybe would expect that. And 3% of men have experienced an attempted or completed rape in their lifetime. So there is a percentage of males, and I know that it's affecting the transgender LGBTQ community as well. The rates have gone up. So who are the perpetrators? The perpetrators are people that you would maybe expect. I think people have the misconception that a perpetrator of a sexual assault is that stranger hiding, in the bushes, or comes up to you at your vehicle or something like that, and it's a stranger to you. But the stats are different. They say that out of every 10 rapes, 8 out of them are committed by someone known to the victim, and we see that all the time with our sexual assault cases here. Here's more stats. Almost 40% are committed by an acquaintance. So it's somebody that the person knows. 33% are committed by a current or former intimate partner. 2.5 are another relative, and 19.5 are committed by a stranger. 6% are committed sometimes by more than one person, or a victim can't remember, so they put that stat in there as well. But it's normally somebody that the person knows. It's not the stranger. When I was growing up, that's what you were sort of afraid of, and it's actually not the case at all. It's someone known to the victim. So here's just some faces. These are all convicted sex offenders. These are all cases that I've had over the years. Starting in the top left corner, that's Jeremy Scott. These are all, again, sex offenders. You can look them up on the sex offender registry. He perpetrated sexual assaults on his stepdaughter. Very kind of good thing and good story that came out of that. We went to trial, and this girl testified. She was about 17 when she finally testified. And she's actually remained in touch with me over the years. I actually attended her wedding last year, so I think that's pretty cool. And we try to help victims as best we can. And I remember this case because it was very difficult for her, but we worked her through the whole phase of the trial, and we got justice. He's doing life in prison. The man next to him with the glasses is Richard Schilling. He was a grandfather who perpetrated sexual assaults on a young granddaughter. Kimberly Sauto is the dark-haired lady there. She was a dance instructor, and her victim was a male student that she had. The male next to her is Deshaun Shields. He was a boyfriend of a mother of the victims, 2 twin daughters. Down there on the left-hand corner, the blonde is Heather Botner. She was a bus driver, and her victims were, 12 and 13-year-old boys that she drove on her bus that she got into a relationship with and gave them alcohol and then had sex with them. Michael Person is the one next to her. He was, again, a boyfriend. He was actually the boyfriend of the victim. So they had a relationship, but it turned violent and he sexually assaulted her. Next to him is Greg Kudla. He was the biological father and perpetrated sexual assaults on his own daughter for many years. Michael Thompson is next to him, and he was a volleyball coach who took advantage of one of his volleyball players. So I just wanted to give you kind of run the gamut here of people. They're from different walks of life, but they all have been convicted of sex offenses. And these are the people that are committing them. They're people known to the victim in some way, more than just a stranger. So where do sexual assaults occur? These are stats again that we just looked up and updated. 55% at or near a victim's home. That makes sense. 15% might be in an open or public place. Sometimes we've had sexual assaults in bars or places like that. 12% at or near a relative's home. And that also makes sense if you think about it. If it's a relative who's perpetrating sexual assaults, it would happen at their home. 10% are enclosed, but public areas like parking garages, things like that. And 8% are actually on school property. And this pertains to a lot of the child sexual assaults that we have. I wouldn't say a lot, but a number of them. So who are the offenders of children specifically? The stats are showing us that an estimated 59% of the perpetrators are known to the child, but are not family members. So these are, as you can imagine, mom's boyfriend, babysitters. We've just indicted a man, a babysitter for taking advantage of the child he's babysitting. Childcare workers, unfortunately. They can be neighbors, we've had teachers, we've had coaches, family friends. They're people that put themselves in positions of trust with families and with children. About 34% of the perpetrators of child sexual assault are family members, fathers, stepfathers, grandpas, uncles, people in the family. And only about 7% of the perpetrators of child sexual abuse are strangers to the child, which again, it makes sense. If you have access to the child, you're more likely to be able to take advantage of that access and that relationship. So the offenders of children, many are pedophiles. That's people who are attracted to prepubescent children. Paraphiles are people who are attracted to post-pubescent, but still like people under minors, so under 18. Many are just situational offenders, however, people who put themselves in positions where they have access to kids. They are normally people the child knows, the child trusts, the parent trusts. There's a relationship with the family, and then the person will take advantage of that relationship and that trust. We use the word grooming behaviors, which is something that a perpetrator uses to ingratiate themselves to the child. It's being the fun guy or the fun uncle or what have you, buying gifts, arranging special activities. And the parents usually love this person because they want to babysit for me. That's great. So they're definitely people who put themselves in positions of trust. I went to a seminar once talking about pedophiles and paraphiles, and a lot of them purposely, because they interviewed them, and we listened to the interviews of these offenders say, I purposely wanted to be a coach because I could be around kids, or I purposely wanted to work at a pool so I could, again, be around children. So those are just some of the sort of the background on some of the offenders, unfortunately, of children in our communities. As to all sexual assaults, 69% of people who have been sexually assaulted will not report that assault to the police. If it's reported, only half, 50%, have a chance at an arrest being made. And then once an arrest is made, that's when the case comes to the prosecutor's office. And if arrested, only 28% have a chance of leading to a felony conviction. So we're talking about a very, very small amount that we actually get to prosecute and then obtain that felony conviction and have a sentencing. A lot of times victims don't want to report for reasons you can imagine. It's embarrassing. It's they blame themselves, especially us women, right? Why did I put myself in that situation? I should have known better. I should have taken some more steps to protect myself. Or a lot of times it's fear of not being believed. Sometimes fear of the perpetrator coming to hurt the person or their family. With children, it's definitely reasons more like it's mom's boyfriend and he helps, my mom with babysitting care, or he provides money to us. And if I report this and he leaves the house, then we're going to lose the house. Or mom will be angry at me because now she doesn't have him to help with the bills. There's a lot of things that kids think about when they are actually thinking about disclosing how it might hurt their family and hurt their parent. Sometimes the victim who is sexually assaulted doesn't want to report because they actually, like in the case of a father or stepfather or a grandfather, they love that person and they don't want to have to disclose this, even though they know and they learn as they get older that the sexual assaults, the perpetration of the abuse is wrong. And sometimes it's just fear of what's going to happen in the judicial system, things we see on TV, how's it going to be, and the fear that's there that comes along with that. So we have a lot of things up against us when we're trying to charge these cases and prosecute them. A lot of, barriers to convictions and justice. So how does a sexual assault case begin? What happens and what's our role as a prosecutor as we go through the system? So first of all, the police have to do their investigation after someone has reported a sexual assault. And they come to us many times to review charges. And we then present those cases to the grand jury. After it's presented to the grand jury, which I know you've heard about the grand jury and how things work there, there's testimony there, and the grand jurors indict if there's probable cause. After a presentation of the grand jury and an indictment, we have an arraignment, which the person pleads not guilty or guilty. They always plead not guilty. No one would ever plead guilty at an arraignment. Their lawyer wouldn't let them, that's for sure. But then we go through the pretrial process, and that's getting all the information about the case to the prosecutor and then to the defense attorneys. From there, we have either a plea or we have a trial. And that's a whole nother kind of step or process. So like I said, with the grand jury, detectives will come to us before we go to grand jury. We work with them, we review their case. We try to give advice to make the case stronger. We try to make these cases as strong as possible because these are, I'm going to tell you, the toughest cases to try. They're most difficult because of the content and proving what happened. So we assist them with writing up their search warrants, drafting appropriate charges, and we work really hard to make the case as strong as we can. So the first kind of consideration prior to grand jury for me, when I get a case I need to look at before it's been indicted, I have to look at the type and the quality of the evidence. Our office is standard, so at grand jury, it's right, probable cause, right? More likely than not, this person broke the law. However, in child victim cases, as well as adult sexual assaults, we want more. We need more information to corroborate the statement of the victim. We can't just take a case that's somebody says something happened against somebody else. We need more in all fairness and in all justice, but also to corroborate the statement and make a good case. So we look at the age of the, let's say, a child victim. If a child is 6 years old and is talking about things that they shouldn't know anything about, that corroborates their statement. How can a little kiddo know about sexual things unless that happened to them? So we look at that statement and how the child expresses that. We look at maybe prior consistent statements. Did they tell grandma first and then told mom, or they told a teacher first and then told mom? Also medical findings. Of course, DNA is always something, it's fabulous when we have that in a case, and we have amazing cases with DNA. However, a lot of times these are cases, especially with children, that molestation is ongoing for years, and you're not going to have DNA. And they might report when they feel safe. Maybe mom's boyfriend, they broke up and boyfriend moved out. And that's when the child is going to come forward because they feel safe enough to disclose. So we're never going to get DNA in those kind of cases. But we do look to as much evidence as we can to corroborate the statements of the victims. That makes our case as strong as it can be. So who testifies at grand jury? We have detectives, sometimes medical professionals, what we call SANE workers, sexual assault nurse examiners, who do the examinations on sexual assault victims. Those are for adult victims. Sometimes social workers, sometimes the victims, if in some cases, usually not, but in some cases we may need that to happen. Sometimes parents and guardians of children will actually come in and testify too. So once a case is indicted, what's my job? What are we doing here? Well, I have to take my case, I have to evaluate the evidence. My evidence should support or corroborate the story of the victim's assault. And again, the goal here is to bolster the credibility of the victim. Okay, well, why? Well, folks, the only real defense to a sexual assault case, and there's only actually like pretty much two, is one is for the adult victim, it's consent. It was not rape, it was not force. She consented. Why is she saying it was force now? That's normally our defense to an adult sexual assault. For a child sexual assault, it's the defense of it never happened. She's lying. You know, you don't have any DNA, so how are you going to prove this actually happened? And that's a hurdle. That's difficult. And again, we look to the lack of sophistication of the child, the details that she's or he is giving to help bolster the child's credibility, because that's usually the defense is she's lying. Once in a while, we'll get the defense of some other dude did it and it wasn't me. It was, you know, it wasn't dad, it was mom's ex-boyfriend or something like that. But those are the things we're battling. So whatever we can do to bolster the credibility and get more evidence to keep our case strong, we look for that. So we interview many witnesses, maybe that weren't interviewed by the police even. We'll interview maybe a grandparent or a sibling. Did a sibling ever see some weird behavior, grooming behavior? Did they ever see, you know, ex or boyfriend take younger sibling into a bedroom alone for a long time? You know, we'll talk to other people that might give us more information. Children's Services Board workers sometimes interview the family members, sometimes even the defendant, and they can actually give us some information. Teachers, school counselors, these are people that a child may disclose to first before they disclose to a parent, because it just might be easier and they're afraid to tell the parent, so they tell a trusted adult first. So we want to talk to them. In both child and adult sexual assault cases, you know, whoever the victim first disclosed to is important to talk to them. Maybe friends and family. Sometimes we have a friend of a child, maybe a 13 or 14-year-old discloses to a friend first. Sometimes those friends tell their mothers or fathers, who then contact the victim's mother. So we want to interview those kids and those people as well. So we look to other evidence in terms of medical evidence, medical providers. Kids always go to what's called the CARE Center, the Child Advocacy Center at Children's Hospital if they're in Summit County. They do an interview, a social work interview of the child, and open-ended questions are given to them: who, what, where, when, why. They don't, you know, they want the child to talk about what happened, and they don't want to pull answers from them. That's leading. So they talk about the child. Has anything ever happened to your body that you felt you didn't like or you were uncomfortable with? Things like that. They let the child tell their story, and that's videotaped. So we actually have that evidence that we can play in court later as part of their medical history and their medical record. We sometimes talk to the ER doctors that dealt with the child. And again, with adults, it's SANE nurses, sexual assault nurse examiners. They work at the different hospitals. We work really well and close with the PATH Center at Akron General, but City Hospital also has a good unit as well. These nurses document any physical injuries. They're also the ones that do the sexual assault kits, where they're trying to collect DNA type evidence. So that they're always very important in our cases. Sometimes we have the detectives go to the house. You know, the child said something was in the bedroom, and they can go to the bedroom and look for that item. They can do a search warrant. You know, if the child said, you know, I don't know, something weird was hanging in the bedroom, or the person had a certain blanket that he always used when this happened to me, we'll look for those things and we'll obtain those. And that could be part of the evidence to corroborate the child or even the adult victim. Counseling records can be important. If they talk to a counselor about the abuse, that can actually come in, because that's a medical record, and that comes in at trial. Sometimes school records, and we now do a lot of social media information, text messages, Facebook messages. Sometimes a victim can talk to somebody on a text message, the perpetrator, you know, why did you do this to me? Or, oh my gosh, I think I might be pregnant. You didn't use anything to prevent pregnancy. And you try to get them to maybe say something back, and that could corroborate the victim's statement. If the perpetrator says, well, you shouldn't get pregnant because I used protection, or I don't know, just things that will bolster, again, the fact that this happened to the victim and it was not a willing act. Especially with children, again, because it's different with kids. If you're under 13 and you engage, if a child's under 13 and you engage in any kind of sexual contact or conduct with them, it is like a strict liability. There's when you're found guilty, that's it. Similar acts are things that happen maybe if they perpetrated on one, say, grandchild in the past, and a younger grandchild now comes forward and says, this happened to me. I've had other grandchildren who are in their 20s come out and say, oh my gosh, that happened to me when I was 8 years old also. And that also can be information that we can bring in at trial. So how do we prepare either adult or child for trial? We absolutely meet with them many times, I wouldn't say many, but several times before court. We don't want them to go in there not knowing what's going to happen. We explain our role. You know, I'm the prosecutor, and especially with a kid, I'm going to talk in kid terms. My job is to prove what happened to you and that it was wrong and that he broke the law. So I try to explain my role in a way that they can understand. Things like what the judge is. The judge is the person that's kind of like a referee. You play a sport, the judge is the person that makes sure both the defense and the state, so the prosecutor and the defense attorney, play by the same rules. So we try to explain it to kids, especially we try to build that rapport with adult and kid victims. And of course, we're going to answer any questions and address their concerns. What's trial going to be like? You know, is it like I see on TV? Which it's not drama like that. I tell people that all the time. You're not going to get yelled at in court. You're not going to get harassed by a defense attorney. The judge is never going to let that happen. So we address concerns, things that make them nervous about having to go to court, about, you know, what to expect, even just little things like, what do I have to wear to court? And we address all that and work with them. So when it comes to child victims, like I said, we meet several times, we prepare them, we build that rapport. I use kid-friendly language. We sometimes ask them, you know, do you want to use a support object? Do you want to bring your teddy bear with you? Do you want to bring something like that? And they can do that. There's also some law that says we can bring a person in who's a support person, like, you know, a good family friend or a teacher or a counselor, and they can sit in the room while the person testifies, and that sometimes comforts children. We can also have our canine companion Avery, as you see there in the picture. He'll come in and he'll lay right where you see him, kind of under the chair there where a child and or an adult victim would testify from, and he'll just lay there for support. And a lot of times, man, that really helps, especially kids, feel a little more okay and calmer in court, because it can be very anxiety producing. We sometimes are allowed to use closed circuit TV with kids to testify. They can be in another room, because facing the perpetrator for any person, adult or child, is going to be anxiety causing. So a lot of times we can ask the court, if the child's counselor says, look, it's going to cause them extreme anxiety, I'm very worried about their mental health, that they have to confront, look at, see the defendant in court while they testify, we can ask the judge to do it by closed circuit TV. That is possible. We do take the children and adults, if they want, to the courtroom. Here's what it looks like. Here's where you're going to sit. Here's where the judge is going to be. Here's where I'm going to be. And your mom or whomever is going to sit in the back right there. And that's so they know what to expect. So it's not as scary, you know, try to make it less anxiety producing. When I talk to kids too, sometimes I've learned that pronouns can confuse them. Certain words are just real confusing. Like, so prior to that happening to you, as an 8-year-old going to know what I mean by prior to that. You know, we need to use words to help them understand the question. And I ask too that the judge instruct defense attorneys to ask questions to kids that they can understand, because some words, you know, when you testify, kids don't know what testify means. I need to say, when you tell your story about what happened to you. So we try to use words that kids can understand. And even when it comes to trial, make sure that they're asked appropriate questions. So similarly, preparing a adult victim for court, you know, we're going to review their statements with them. If they had an interview, and this is for kids too, we're going to play their interview with them. Do you remember saying these things? It might be a year and a half before we actually go to trial from when they already came forward about what happened. So we want to make sure they remember everything, and then we know everything that they know. We may ask about things in their background or facts that maybe the defendant might know that we don't. It's not in a police report. Things that we should know. We don't want any surprises. So we talk about those things. And we ask them to hang on with us and help us prepare them when we sometimes practice some of the questions that might be answered. Not so much what their answers are. I want them to just tell the truth. That's what we tell everybody. Whatever the truth is, that's what I want you to tell. And who can be present in court during the trial? Well, that can be anybody who's not testifying, or they have to testify first, but then they can sit in the back and they can watch. And we always have an advocate present in court for any of our victims. So moving on to the trial phase, If you've ever been on a jury, it's something nobody sees on TV, but the jury selection is a very important part of a trial. And we have to pick the appropriate jurors that we feel are going to be good, unbiased, focused, open-minded jurors who are going to see and hear this case with an open mind. And actually, the goal is the same for the defense as well as the state. We want fair and impartial jurors. So that process is important to us. The process is called voir dire. That's how we pick a jury. It's questioning the jurors and having their answers. Our goal is to get, again, fair and impartial jurors. The types of questions we ask a jury panel, just what's your background? What kind of job do you have? Have you ever testified in court before? Have you ever been yourself a victim of a sexual assault, or do you know anybody who's been a victim? On the other side, do you know anybody in your family or you yourself who have been accused of a sexual assault or a crime? We want to pull information out so we can try to choose jurors, again, that are going to be unbiased, because everybody comes to court with life experiences. And we want to learn as much as we can about our jury panel and picking our jurors. Each side has what's called 4 peremptory challenges. We can dismiss 4 people on the jury panel, anybody we want for whatever reason we want, from, I didn't think they were really paying attention, or I didn't really like this answer, or whatever it is, we can get rid of them, and each defense and state gets 4. We also have challenges for cause, where for some reason we feel the person might not be able to be open-minded. Let's say somebody was a sexual assault victim, and the minute we start talking about this case, they start crying. We know that they're going to have a really hard time being open-minded to both sides, the defense and the state. So we'll dismiss them for cause if that happens. We want 12 jurors, and we get several alternates when we finally seat our jury. So the trial process, it's the state's burden of proof. We have to prove our case beyond a reasonable doubt. We go through, first of all, opening statements, which is where we're going to set forth what our case, what our evidence is going to show. When you hear the story of Sally Smith, you're going to learn that Sally lived with her mom and her mom's boyfriend. And during the times when mom was at work, mom's boyfriend would come into Sally's room at night, and we'll tell the story, and we'll then put forth what our proof is going to show and what our charges are. The defense does the same thing in their opening statement, and they put on what they think the evidence is not going to show or is going to show. Then we put on our evidence. So we have witnesses, right? Victims, the lay witnesses, that would be like mom or a friend of the victim, teachers. We want medical professionals if they were involved in getting any DNA evidence. Law enforcement, of course, comes in to testify. Sometimes we have experts, sometimes experts in, like child abuse, who come in and actually testify to how a child would react to a sexual assault. Like, why didn't they report right away? I mean, wouldn't you report right away? And these abuse specialists can say, not in my experience, and here's the reasons why. We'd like physical evidence if we can, DNA, of course. Unfortunately, there might be injuries sometimes. Things like the pictures from the house, a child's or adult's clothing, medical records that have pictures with injuries. We're going to use all of that. That's all evidence in our case. The defense may or may not put on any evidence or witnesses. They don't have to. And the state cannot call the defendant to testify. I cannot do that. The defense has a choice whether to testify or not. That's up to them. After they put on a case, maybe, we do closing arguments. We say, look, here's our charges. Here's what we showed. Here's how we prove that this happened. Find the person guilty of these charges. At the end of that, the judge instructs the jury on the law, meaning here's what the law is, and here's what it means, and here's what you have to do in following the law. So the jury then goes into deliberations. This is a time when we're all kind of waiting around, the lawyers and the victims and the families, trying to determine, okay, how long is this going to take? Sometimes a jury will deliberate for, I've had juries come back in 20 minutes on cases. I've also unfortunately waited a couple of days for a jury verdict, and that can be really stressful as you're waiting and the family members and the victims are waiting and wondering what's going on in that jury room. Because if you've ever been on a jury, you would know that it is confidential. Nobody can be in there with them. Nobody can listen to their deliberations. We can't ask them about it. They're not allowed to talk to anybody about their deliberations until the jury verdict is read in open court. So they're even instructed, you cannot go home and talk about this. You can't talk to your family members. You cannot Google anything. You cannot, look at anything on social media about this case or regular, media. It's all them in there looking at only the facts and the evidence that was given to them in court. So sometimes that can be kind of scary while we're waiting for those verdicts. But they're also, by the way, not sequestered. People think sometimes that juries, okay, that means I can't go home. I have to stay in that jury room and go to a hotel. No, they go home every night at the end of their deliberations, unless it's an aggravated murder trial with a death penalty specification on it. Those are the only jurors that are actually sequestered. So when we get on to a sentencing, hopefully, right, we get our conviction. Sometimes, by the way, they do, in many, I'd say the majority of cases, plead guilty. But sexual assaults, again, are some of the toughest to prove, hardest cases. And a lot of times, those are the cases that go to trial. But hopefully, after that trial, we get a conviction, or maybe we get a plea and a conviction. We talk about sentencing and what goes into sentencing and what's going to happen in that hearing, because that's a whole separate hearing that goes on with the court, the defendant, and the victims and their families. So we do what's called a pre-sentence investigation, especially in a plea situation. That is where the judge gets a big summary of all the facts of the case, what happened, what the evidence was, any statement by the defendant, things like that. And the judge is going to review that in determining what the appropriate sentence is going to be. In a trial situation, if we went to trial, the judge has heard all the evidence already because she's sitting there in open court listening to everything. So she may not need a pre-sentence investigation for that particular type of case, but those are available for pleas for sure. Victim impact statements. So we prepare our victims for these pretty much from the beginning of a case when it's filed. They are very important for a couple reasons. One is it gives the victim their moment to state how this affected me, how it affected my family. They can write a letter to the judge. They can read a letter in open court. They can just speak in open court at sentencing. Family members, you know, a mother or a parent of a sexual assault victim will be able to have their moment too to say, you know, this is how this case has affected my child or my sister or what have you. So those folks are allowed to present, I guess, information that they feel the judge needs to hear in order to give the appropriate sentence. Sometimes we've had even kids counselors come in to talk to a judge at sentencing as well. A lot of times, this is also a time for the victim or victim family members to actually speak to the defendant. They don't really speak back. The defense is not going to allow their defendant to talk back to family members or victims, but it's a moment for the victim to be able to look that person and say, now people believe me, you have been convicted for what you did, and now you're going to face sentencing. And it's very cathartic, I think, and I've seen for family members to be able to do that in sexual assault cases and in all cases where there are violent offenses. Also, if they don't want to read a letter themselves, we have victim advocates who are happy to read the letter to the judge on behalf of the victims or their family members. In sexual assault cases, we also do what's called a psychosexual assessment. Not in all cases, but in many of them. Some of these cases are life in prison sentences, so we may not do a psychosexual assessment in those cases. But in cases where it's a lower sexual assault crime, we'll do these assessments where someone basically goes to with either Summit Psychological, which is here in Akron. So we have some amazing doctors there, forensic specialists, psychiatrists who specialize in sexual assaults and the counseling of people who perpetrate sexual assaults. And they do assessments where they look at the risk of that person doing this again. How, I guess, what information do we have that this person is going to act out sexually again? And what can we do to prevent that? Because some people, when they get out of prison, you know, they're going to have to go into some kind of counseling or, you know, care in order to change, hopefully, that way of thinking to perpetrate on people. But sometimes I've heard and read and been in seminars where I've heard that, you know, if they're a pedophilia or pedophile, they're going to always be a pedophile. You can't change that. That's part of their nature. But in any case, these sexual assessments give us an idea what the sentence should be and what the judge should do, and it's very important information. And it also goes with them to the prison as information for the prison counselors and people there. So sentencing, it kind of all depends on the type of charge. So rape of a child under 13, that's engaging in any kind of sexual conduct with a child under 13. And I mean, obviously I'm being really frank here because this is kind of what these cases are about. It doesn't have to be what's called, regular sex or sexual penetration. Oral sex is also sexual conduct. Any kind of touching of the erogenous zone of another is a sexual contact. So that's contact. And that would be also charged, it's called gross sexual imposition. But in any case, a rape of a child, though, under 13, any kind of sexual conduct with a kid under 13, life without parole is an option for the judge to give. If the judge chooses not to, and it kind of rarely happens if they give life without parole, if they don't, then there's mandatory sentences based on the age of the child. If the child is less than 10, it's 15 to life, meaning it's life in prison with parole eligibility at 15 years for the first time you're out for parole. At that point, you might get denied parole. You come back 4 years later and you are requesting parole again. And it kind of goes from there until maybe you're granted parole. But you're serving 15 years until you even get the chance to go before the parole board for the first time. If the victim is 10, 11, or 12, it's a 10 to life, so life in prison with parole eligibility after 10 years. If a defendant used any kind of force, threat of force, or has a prior conviction or caused any serious physical harm to a child victim, it's life in prison with parole eligibility after 25 years. That's the mandatory sentence. So if a victim is a minor still, age 13, 14, 15, 16, 17, or 18, and then over 18, we call it like a straight rape, meaning the sentence is 3 to 11 years. So it can be 6, it could be 10, anywhere in that range. It is not a life sentence if the victim is 13 and over. So straight rape is a rape with force. You don't need force on a child rape. You just need the sexual conduct, period. You don't have to show force. But with a straight rape on a 13 and up person as a victim, we have to prove that there was force or threat of force to accomplish that sexual conduct. So here we go, moving on to the last little bit here, sentencing. We also have the sexual violent predator specification. If that person has committed offenses in the past, and under the law we find is likely to engage in future more sexually violent offenses, we can add additional prison time on top of the sentence they're already getting. Sexual offender classifications. These are the labels that you might hear that people get if they are sex offenders. They're labeled in a tier system, and that is in the law based on the type of offense they committed. So if they committed and are convicted of a rape or sexual battery, it's called tier 3, and they have to register with the sheriff in the county where they reside for the rest of their life. Every 90 days, they have to verify their home address every 90 days for the rest of their life with the sheriff. If they don't, and they skip, a month or two, they can get charged with a crime, a felony of failure to register your address, which is another crime. Gross sexual imposition, like I said a little earlier, is sexual contact. So that's touching of the private parts of another person. For a child, just doing it. For an adult, you have to use force or threat of force to get that conviction. That is a 25-year registration requirement, and you have to verify your address with the sheriff for 25 years every 6 months. The lower tier is for a charge like unlawful sexual conduct, and that's a 15-year registration requirement, and you have to register, verify your address with the sheriff for 15 years, once a year. And the purpose of this, people ask, we get calls sometimes where I know this guy's a sex offender, and he's having a party and there's kids at his house. Well, unfortunately, there's nothing anybody can do about that. The classification system is there to give people basically a heads up. This person may live down your street. Just be aware that this person is here and they are a whatever tier sex offender. We can't keep them from being around like their children or family members or things like that. Only their parole officer can do that when they're on parole. But if they're off parole, nobody has control over that. So the sexual offender classification system is to give everybody, a heads up. Here's a warning. Here's some information. Just be aware for your own safety or that of your children. So the Summit County Sheriff's Office has their sex offender website, which I have up there. Anybody can go to that at any time and look up sex offenders near where you live. You put in your address and it will populate on a map where the sex offenders live within your community. And you will actually receive notification in the mail, I believe it's still in the mail, if you live within 1,000 feet of the tier 3, like the worst sexual offenders. But normally you're not going to know where they are unless you go on this website and you look up the person, I'm sorry, your address, you put it right in there, and it will populate then anybody who is registering as a sex offender near your home. I've also used this in another county, in Cuyahoga County, near my in-laws' home, because they used to take care of my kids a lot. So we put in their address, and I receive alerts when someone lived within, I think it's like a 3-mile radius or so of your home. So it's something to look at, something to think about. You can also, if you know someone is a sex offender, you can go ahead and put their name in, and it will show you where they are as well. And they, again, have to register and keep this information updated. So that is all I really have. I could tell you a million more stories of all the different cases I have. It's been very rewarding to have the job that I have and to work with adults as well as kids and helping them find justice and find their voice. I always tell them this is the time to take back the power that was taken away from you when you were a child or when this person did these things to you. Now it's your turn to take that power back. And I've seen many kids come to court and even make statements and just come out of this so much stronger. Like I said, the girl who I just went to her wedding last summer, it was amazing to be there. And another little amazing part of that was the detective who was on the case with me and tried the case with me and worked it hard. He actually walked her down the aisle. We thought that was pretty cool. So do you have any questions? I think I have a minute, maybe, or two.
Hi, Jenny. Yeah, we actually have a couple of minutes. You're good. Thank you very much. There's a lot of information there. I appreciate you taking the time tonight to do that. Going back through the chat, there was a couple of things that I wanted to address. One was the Joyce, I think, put in, why does it seem convicted female teachers tend to be treated less harshly than convicted male teachers? I'm not sure about that. I went through a couple of our, while you were doing your presentation, I went through a couple of our things. I know that we've had, in my memory, at least 2 female teachers, Laura Cross and Laura Busey. One was Akron, one was Twinsburg. And I think they both got a couple of years. I think you've hinted both of them.
You're right. I mean, we've had cases, and I've had to argue very strongly in those cases that even though people kind of maybe look at those cases differently, that the law doesn't look at them any differently. And we have had, I had the one Laura, the first Laura you just said.
Cross.
I forget her name. Yes. Her victims were over 13. So I'm sorry, not victims. It was one victim, but he was like in his 14, 15, 16 when they were engaged in sexual intercourse. And it was a hard situation. He didn't really want to even prosecute, but it really affected him. And I think he found that out later as we went through the process. But we argued for prison time for that. It would not be this life in prison because he was over 13. It was a certain amount of years. I think we did 3 or 4 years there. But yeah, sometimes we do have to really argue harder for, hey, there should be no difference in these. And I think the judges are getting it. I've seen that them giving pretty appropriate sentences on those cases when it comes to female perpetrators.
Grace asked, and I apologize, Grace, I didn't quite understand your question. So hopefully Jenny can answer this. Grace is asking, what is the definition of unlawful sexual conduct with a minor? And how does it different from the different tiers that you had put up?
That's funny she said that, because I actually had some information on that, but I thought I better get moving through some of this. So yes, unlawful sexual conduct with a minor is consensual sex, so not with force or threat of force, and it can be between the ages of 13, 14, 15, because the age of consent in Ohio is 16. At 16, you can consent to have sex with anyone you want. So if it's a person who is 18 or over and they're having a sexual relationship with a high schooler who's 14, let's say, then that is unlawful sexual conduct. It's like that strict liability situation. They're that lower tier unless they're, I think, 10 years difference in age, then they go up a tier. Because the sentence for, if you are 4 years, less than 4 years older than the other person, it's only a misdemeanor actually. If the offender is 10 years or more older, it's going to be a higher prison sentence from 1 to 5 years. So it depends on the ages of the victim versus the perpetrator. Because a lot of times we do have, 14-year-olds, 13-year-olds that have sexual relationships with 18 or 19-year-olds, and those are unlawful sexual conduct with the minor cases. And we do prosecute those. unless like a parent or guardian says, absolutely not, we don't want you to prosecute this, then we won't go forward. But normally they do want that person prosecuted. So yes, we go forward on those cases.
Grace also asked the statute of limitations for child abuse and or sex crimes. I know it was 20 years. I don't know if I know the state legislature was looking at extending it to 25 years.
Yes, it's 25 years
It's 25.
for sexual conduct cases. So rape, sexual battery, those cases are going to be statute of limitations of 25 years now. Some states have no statute of limitations. So there's no statute of limitations on murder. And we've been, people have advocated here in Ohio to get rid of the statute of limitations altogether. That hasn't happened yet, but in a lot of states, there is no limitation, no statute of limitations for rapes, for sexual assaults like that.
Then another question asks if we've had any defendants plead guilty with child victims. We've had a number of.
Oh, we have a lot of them.
Defendants plead guilty.
We do. We definitely have a lot, especially if we have cases with DNA. They're kind of in trouble, right? So we do have a lot of them that plead. I don't know, stat-wise, maybe half of them, in my mind, in my cases, sort of plead. But yes, we definitely have pleas.
And in your presentation, I missed it as well. We get a number of life without prison sentences, or life in prison without parole sentences, but not when it comes to, we get a handful of them. Great, Grace, did you say it's rare that we get life without parole is given?
Yes. So a judge always has that chance in a child sexual assault to give life without parole. It's their discretion. I don't think I've ever seen a judge do it. They just kind of fall back on the, well, what is it? The sentence statutorily, mandatorily, it's 15 years to life. When they do give life without parole, and I've had it a couple times, it's if the person was also found under that specification, the sexually violent predator specification, where we have an actual hearing where I had one, for example, where there were two young victims who this friend of the family, was molesting. He was convicted for those two girls, and then his two of his sisters and a cousin came forward at our sexually violent predator hearing and said, we are also victims of him when we were young. He's been doing this since he was 20 years old. He's now 48. If we show those things and he's found to be sexually violent predator under a certain code, part of the code, the judge has to give life without parole. Just like if he would be a sexual offender like that and cause some serious physical harm to a young child, something really horrible, then yes, life without parole is mandatory, but it's rare. It's harder to get to in the law, unfortunately.
But also a lot of these times it's not just, that's the minimum sentence of parole after 15 years. If you have multiple charges, because there are multiple incidents, the judge can stack those sentences to where, they can make them consecutive and not concurrent. So you can get, a higher level of a sentence. Danielle, I'm sorry.
No, I was just saying the one, my friend now, who was a victim, who I was at her wedding last summer, her molestation, it occurred for 4 or 5 years growing up. So we did have multiple counts of rape, 1 or 2 for each year that this happened. And the judge did give him it was 120 to life. So that's kind of life without parole, right? Yeah. She stacked them for each, for her. So yeah, that can happen.
Danielle mentioned that there's a tier 3 sex offender that is allowed to move on her street, bought a home near a school. Please explain how they got away with that. There's nothing, as far as I think we know, that prevents convicted sex offenders, unless it's within a close proximity to a school.
1,000 feet of a school. They're not supposed to live within 1,000 feet of a school. I had at the school where my kid goes, there's the school and then a big football field and baseball fields and all this stuff. And one of the sex offenders moved across the street from the football field. And I thought, that's not right. So I called actually our civil division, because the civil division in our office handles complaints like that, and then can get the person or make the person get an order to move if needed, if they're in 1,000 feet of a school. But it's within 1,000 feet of the school building, not the property, not the football field, which I thought is wrong and should not be the law and should be changed. So that might be the situation that she's referring to, is maybe it's not within 1,000 feet of that school building. If it is, you can make a complaint, and that can be dealt with, and hopefully the person will be made to move. That does happen.
Yeah, that's good. Thank you for explaining that. One more. Alexa asks, a 16-year-old could have sex with a 23-year-old and there's nothing you can do about it.
It's not illegal. That's what I guess I'd say is it's not illegal. I mean, we've had people come to us like, hey, I have a 16-year-old and she's having a relationship with I've had it with a 40-year-old. And it's like, well, if it's consensual, the law says we cannot prosecute. It's not illegal. Definitely wrong. And hopefully there's other ways to deal with that, whether it's counseling for her or somehow breaking up that relationship. But legally, it's not criminal to have that relationship.
Unless the older person is a teacher or a coach of
Yes.
that younger person.
Yeah, absolutely. If they're a coach, if they're a teacher, if they're some kind of clergy of some kind, that's considered sexual battery. So yes, that would be something because they're in a position of authority. That's what the law says. Well, they're in a position of authority over that 15-year-old in their high school, or they're the basketball coach and they say, hey, we got to have this relationship or I'm not going to let you play. You're going to sit on the bench. So they have that power and authority over a person. And that's why the law says, yeah, that's not going to fly. We're going to make that an illegal conduct.
We got another one here from Grace about, do you handle child sexual abuse material, CSAM cases? If a parent is charged, would their own children automatically be interviewed or potentially removed from the home?
So if there's an allegation, is that what you mean?
Yeah, I know, Grace, if you want to turn on your mic and ask that question, I'm just reading it on the chat.
So I was wondering, like, if a parent is convicted of possessing child sexual abuse material, not of their own children, but if they have that conviction, would that automatically warrant Children's Services, say, to investigate their own children because of maybe a higher risk of them being victims? Or how would you handle that if it's, child sexual abuse material of other or unknown children, but there are also children in the home too?
So we have a lot of, unfortunately, child pornography cases like that, and there's charges like pandering, obscenity involving a minor, things like that. If there's an allegation of that, and especially if there are charges that are filed in regard to having and viewing that kind of material, there is always going to be a referral to Children's Services to say, hey, this person had all this stuff here and they have kids in the home or they have access to children, and they will open a case to come out, interview the kids. Sometimes the kids are taken to the care center at Children's Hospital and are given that, a social work interview to see if anything's happened, maybe, because that's a key, right? That's a red flag for sure. So yes, normally in my experience, CSB does get involved and at least go out and interview the family, interview the kids. Yeah.
Okay, I think I got through all the chat. If anybody else had any other questions, you can just pop in with your mic. Catherine just asked, what if a teacher is doing this and the superintendent won't acknowledge it? That's difficult. If I said, if there's evidence of a crime, you can, take that evidence to police and that could supersede whatever the superintendent does or doesn't do. If it's a
Right.
criminal act, the police need to be made aware and can investigate, and then, depending on it, let us know.
Can I intercede there and just ask a question?
Hold on, I think you just gotta lower your,
My volume.
we got,
Can you still hear me?
we can just, if you just lowered your speaker, you should be okay.
Okay.
This is a situation that happened several years ago, and it was brought to the superintendent's, and he called the sheriff. The child was afraid and denied it. And as the child's older now, so the teacher is still in the system. She has approached other children, students, and the superintendent wants nothing to do with it.
That's a situation where if that child is older and feels, confident enough or, whatever, to go to the police now, they can absolutely go make a police report now. We've had many, many cases where, again, when a child gets older, they're going to look at things, they're more mature, and they're going to understand what was wrong, that was really wrong. A lot of times they don't know until they're older that what's happening to them was wrong. And they will make a report years after something happened. And we do then investigate those just like any other case. So I would suggest that if they want to, they go with a parent or guardian and they make a police report, and then it's going to be investigated, because once a report is made, there's an obligation on the law enforcement to investigate anything like that.
And if this teacher is still doing something like this, approaching students, you know, there's a fine line there. But I think if there's any type of evidence, you know, you can let police know and provide them that evidence, and they will, like Jenny said, investigate. So, all right. Well, I'm sorry, Jenny.
I said, and they might interview those other kids that maybe have had something happen to them. So yeah, that's the way to go if you can.
Well, great. I think, you know, we are a little tight on time again, which seems to be a weekly occurrence for us, but we've got a lot of great information. Jenny, thank you for your presentation. You want to stick around because we've got a lot of great stuff coming up.
Right.
I see Katie Tomko has joined us and Maureen Walsh. Hi, guys. Welcome. It's up to you as to who's going to go first, but I think, Katie, did you want to go first or Maureen's going to go? Katie's going first.
We were planning on me going first. Yes, thank
Awesome.
you.
I will run your PowerPoint, but if you want to introduce yourself and let people know who you are and how long you've been with the office.
Great, thank you. Good evening, everybody. I'm Katie Tomko. I have been with Summit County Prosecutor's Office for 10 years now. And myself and another assistant prosecutor, Ashley James, were recently promoted to the co-supervisors of the Child Protection Unit with the office. And I've been in this unit the whole time that I've been with Summit County Prosecutor's Office. It's a wonderful unit. We do really important work. A few years back, it was originally known as the DN, or Dependency Neglect Division of the office, and it changed titles to the Child Protection Unit, which is what we do. And it's very meaningful and rewarding work. We don't always get the outcome that we would like to see, but it's definitely something that's close to my heart, and that's why I've stayed in this division. And now, as one of the co-supervisors, hope that I can share my passion for this work with the other people in the division. And so we are part of the prosecutor's office, which represents Summit County Children's Services, which there have been some references to previously. And so there's 7 prosecutors total in our unit. And our part of the office, we're not putting anyone in jail, but in terms of representing Summit County Children's Services, we're dealing with issues of custody and things of that nature. And I just put this up here. If you ever develop any concerns for the safety or welfare of a child, you can contact Summit County Children's Services through the 24-hour hotline. The number's there. The reporter's information is confidential. I know a lot of times people may hesitate to call because they're afraid of potential retaliation or something of that nature. That information is meant to be confidential. And if a defense attorney tries to elicit that information in one of our hearings, we with the prosecutor's office certainly object to that. And the court keeps that information out, because the purpose is we want people to come forward and report a concern if they have one for the children. So just a little bit about our process. The parents are appointed counsel if determined indigent, which is basically meaning that they cannot afford to hire an attorney of their own. Those attorneys are always there with the parents at the initial hearing, which we call a shelter care hearing or a status hearing. And then after that point in time, it's on the parents to fill out the necessary paperwork with the bailiff if they're not able to afford an attorney, or they do have the option to hire an attorney if they are able to afford one. I just included this because this has been something that we're all still dealing with in some ways. The pandemic, we've definitely had more cases filed. We're seeing a lot more issues in terms of domestic violence and things of that nature. One of the scariest parts of the pandemic to me was that children did not have access to the mandated reporters such as, medical providers, teachers, principal, gym, coaches, things of that nature. If they were enduring something in the home, there were also concerns as far as sometimes, depending on a family situation, kids may be getting some of their meals at school, and then with schools being shut down and working and being remotely, they didn't have access to that. So we have seen a rise in cases since the pandemic started. So that's definitely been a concern. So just kind of walking you through things at the beginning of the case, Children's Services cases typically start either by someone calling in a referral to the hotline at Children's Services to report abuse, neglect, or what we call dependency of children. And the hotline will either do what we call screen it in or screen out. And if it's screened in, then the intake caseworker will get assigned to assess the situation and investigate. If it's screened out, then basically they've made the determination that there's not enough there to proceed with an investigation. Cases can also come in through what's known as a juvenile Rule 6, which is something where police are on scene, and let's say they respond to a call, there's domestic violence and kids are there, and so they may actually issue the juvenile Rule 6 to place the children in Children's Services custody. And then if the agency does need to file with the court once either an intake is received or a juvenile Rule 6 occurs, then a hearing has to be held within 24 to 72 hours. And I put the 72 because sometimes you'll file on a Friday and then next business day would be Monday when that hearing would need to be held by. And so our first hearing is known as either a shelter care or a status hearing. It's shelter care. If the children are removed, then they're placed in either the emergency temporary custody of Summit County Children's Services, a relative, or what we call non-blood kin, which could be, let's say, a friend of the family that Children's Services has assessed. And at that hearing, basically, so Children's Services will file a complaint. Magistrate will review it, and if they determine that there's enough there just on the face of reading the complaint to place them in custody of either Children's Services or another individual, they'll issue that order, and then there has to be a hearing right away so that all the parties have the opportunity to be represented. And if they want to contest it and fight for the kids to come back home, they have the opportunity in the due process to be able to do so. If the children are not removed from the home, we have something what we call protective supervision or an order of access, which is basically child still remaining in the custody of their parent or guardian, but Children's Services is seeking an order so that they can go and investigate the concerns and have access to the home and access to be able to speak to the children and see the children and investigate those concerns. And so our cases are abuse, neglect, or dependency. They typically involve issues of physical or sexual abuse of children. There can be medical, educational, or another type of neglect of the children. Dependency cases can be a variety of things, and it's not limited to just what I have on the screen here. It's issues in terms of the parents being able to meet the basic needs of the children, such as food, clothing, shelter. The parents may have an issue with substance abuse that can have an impact on the children. It may be the mental health of the parents that's impacting their care of the children, or the parent or guardian being unable to care for the children. And then I just included, these are just the Ohio Revised Code sections that we're governed by with dependency, neglect, and abuse. And then Summit County Children's Services also has to follow the mandates of the Ohio Administrative Code. There should be an E on the end of that, sorry. And so we have kind of two main tracks with our cases, the traditional track, which is where, and I'll go into more detail about this. You have set hearings, or there's our family reunification through recovery court. This is very similar to a drug court that you may see in a criminal proceeding. And basically it's very highly intensive. You're having court hearings every week. There's a set group of caseworkers from Summit County Children's Services who work very intensely in these cases. They're referred to certain providers, and they have treatment team meetings before each hearing each week. And there's an attorney there that's provided for the parents who participate in the program. We as prosecutors are not at every single one of those hearings. We're just at more of the traditional hearings every few months. But the magistrate and the court, and they're checking in to see each week, how are things going? What services are these people involved in? What works, what's not working for them, and really providing a good support system for parents who do have substance abuse issues. In those cases, the child actually has to be removed from the custody of the parent. That's one of the qualifications, and basically a parent and their attorney, they'll go through a whole participation agreement in the program. At the start of it, we have a hearing, and then if they're accepted into that, then they're expected to follow all the rules of that program. So one of the first major steps after you have a shelter care status hearing in our proceedings is the adjudication. The adjudication is essentially the trial. That's where Children's Services has to prove the allegations in the complaint. If we don't prove the case, then it's dismissed at that point. This has to be held within 30 to 60 days of the filing of the complaint with the court. And that's essentially our foot in the door, so to speak. And then after that, we have what we call disposition. Both adjudication and disposition must be held within 90 days of the filing of the complaint. At disposition, that's basically determining whose custody are the children going to be in. And we do what's called adopting the case plan. A lot of times parents get confused and they say, does this mean my child's being adopted? No. Adoption of the case plan is basically where everything in the case plan becomes court orders. And the case plan will have certain objectives on it that'll be, let's say, substance abuse treatment, being able to meet basic needs, mental health treatment, parenting programming, submitting to urine drug screening, submitting to a psychological assessment and following recommendations. Those are what guide the case for us. And then after that initial disposition hearing, then every 90 days, we have what we call review hearings, which are basically updates to the court of how are things going. We address things like, how are the children doing? What if any services are they in? Are there more issues that we've identified that need to be addressed for them? Sometimes the case will come in and have one set of issues, and then the further along we go, we'll see there's much more involved, and the children have been through much more than what we initially knew about. We also address issues of placement, where the child should be. Anytime a child is moved somewhere, Children's Services has to file a notice with the court so that everybody's made aware of that. And we update the case plan to have that information as well. Initially, when children come into care, we may not have any relatives identified, so they may be placed in foster care. But then over the life of the case, parents may identify relatives, or Children's Services has something that they call family search and engagement. And so that's a designated caseworker who makes very serious efforts to find family for placement of children, because that is really the preferred option if available, and if it's somebody that's going to be safe for the child. If they do identify family, then the family member is assessed through what we call a kinship assessment. So a designated worker in that part of Children's Services will check out their background. Do they have any criminal history? Do they have any substance abuse issues? Who all is in the home? Things like that. So we discuss all of these things about placement at these review hearings. We also discuss case plan progress. So this is essentially, how is the parent doing? Are they going to their treatment that they need? Are they engaged in those services that they need in order to reunify with their children? We address visitation as well. How are visits going between parents and children? Where do those visits take place? How often? Are there any concerns with visits that need to be addressed? That's all discussed. And then, of course, whose custody is the child in at that time? Sometimes things will change where if we have identified a relative and they're appropriate and they've been approved by Children's Services, then we may file for custody to the relative. And then the relative having custody and Children's Services having involvement still, make sure that they are safe. And then the relative kind of has more discretion in terms of setting up visits for the parents, things like that. And then next up on our progress here is sunset hearings. So these have to be held within 1 year from when Children's Services files its complaint with the court. And the purpose behind this hearing is that we want some type of permanency for the child within a year of the filing of the complaint. We don't want cases and children just lingering in the system, so to speak. There's a number of different options that can occur at this hearing. Either best case scenario reunification, which is where child's been removed from the home, parent has basically fixed all the original concerns that we had at the start of the case, and it's a safe environment for the child to return to. So then we have reunification where they go back to parents' custody. Another option is legal custody to a relative. This could be a situation where the parents have not addressed what they needed to as far as the services. So it's not safe for the child to go home to them. However, there may be a relative who is appropriate and is willing to commit to care for that child until they reach the age of 18, or if they're still in high school at 18, until they graduate high school, whichever is later. So they're essentially stepping into the role of parent, but the parents still have rights. They still have the right to visit, right to educational, medical information, all of that. So their rights are still intact. It could also be legal custody to what they call non-blood kin, which again would be maybe a friend of the family, or it could be a relative of a sibling that particular child's not related to. We also have a 6-month extension, which is basically where a parent is making progress on the case plan objectives and they're involved in services, but they may not yet be ready for the child to return to their care, or it might not be safe yet. So that's the 6-month extension. And then the other option would be permanent custody, which is where once a child is placed in permanent custody of Summit County Children's Services, then they're eligible for adoption. And permanent custody basically severs the rights. So the parents do not have parental rights to the child anymore. So 6-month extension. With that, we have to prove that it's in the best interest of the child or children for a 6-month extension to be granted. Also that there's been significant case plan progress, and that there's reasonable cause to believe that reunification or some other type of permanency plan would occur for the child. And I have the Ohio Revised Code section there for that. And there can be up to 2 6-month extensions in a case. So really by 2 years into a case, we need to have some type of permanency for the children so that they're not just lingering. And then another option, as I discussed a little bit before, permanent custody. So that is the termination of parental rights. And it could be either involuntary, where we run the trial and then the judge grants that, or voluntary, where a parent does make that difficult decision to relinquish their rights. And then the child's placed in permanent custody. The trial can last for multiple days. And one difference with permanent custody hearings is typically in juvenile court with these child protection unit cases, our hearings are in front of magistrates. But if you have a permanent custody hearing and it's going to be contested where the parents are not going to voluntarily relinquish their rights, then it's in front of Judge Teodosio. And I know with permanent custody, people may get the impression from the outside that, oh, you know, this is what Children's Services wants. No, Children's Services really wants reunification, but they want to make sure that the child is safe and that they're going to have their needs met. Permanent custody is really something that is supposed to be as of last resort. It's where unfortunately no family members are available to take custody of them. And I will tell you, some of the saddest hearings that I've experienced are where Children's Services has filed for permanent custody and their parents have not shown up throughout the whole case. The parents never applied for attorneys, even though it makes it essentially easier to prove permanent custody and to go through those trials. It's really sad to not see anybody there to advocate to have their child back. So it's definitely, those are difficult hearings, but our job is to make sure that kids are protected. And then I don't know if anybody has any questions. I'm happy to answer those.
Katie, there is a question in the chat. Is it true a removed child cannot be placed
in the home?
In the home if one of the parents is a convicted felon? Is that, am I reading that right, Joyce?
Yes. If a parent is a convicted felon or cannot be placed in the home of a relative, if a convicted felon lives in that home, regardless of the felony conviction and regardless of how long ago the conviction took place.
So I think for that, to my understanding, Children's Services, well, I know Children's Service has certain guidelines. First off, in terms of if they're assessing who all is in the home. So if the other parent, if one parent in the home has custody and there's another parent living in that home, since the parent we're removing from is in that home, then I would say regardless of what's going on, we're not able to still keep the child there. If they're living separately,
Yes,
oh, sorry.
Yes, thank you. Go ahead.
If they're living separately and the other parent who the child was not removed from, if they have a felony record, there are certain guidelines under Children's Services directives that they have as far as whether or not a child could go to the custody of that other parent that they were not removed from. So it all depends on their guidelines. And unfortunately, Children's Services actually has that more specific information. It depends on what they were convicted of and how long ago it was. Those are things that can make a difference. And then they make that determination, and then, you know, Children's Services may present their evidence and say, these are our concerns. Based on this conviction, Children's Services is not able to approve of this other parent. But depending on what's presented at the hearing, the court is the ultimate, you know, decider. So they may still place in the parent's custody, depending on what the parent's circumstances are.
Great. Thanks, Katie. We got one other question. Is actually, it's a twofold question. One, are all juvenile court proceedings sealed or private? Either while they're going on, or I guess at the end of them?
So they are private in the sense of, if somebody wanted to look online, you can't access our docket to see the court case or any of that information online. However, our proceedings are open to the public. So if a friend of the family is there and they want to come into the hearing, it's a public hearing, they're able to do so. It's just that given that our cases involve minors, you can't access the docket to our cases. So it's private in that sense.
And then the last question is talk maybe a little bit more about the appeals process after a sunset hearing.
So if there is a legal custody hearing or something that's in front of the magistrate, then once the decision from that's issued, a parent would have 14, or whatever party would have 14 days to file an objection with the court, and that would go to judge, and then the judge would review it. And then if the judge sides with, or, you know, basically affirms the magistrate's decision, then from 30 days from whenever she issues her decision, then you'd have that amount of time to appeal it. And then once it gets to the appellate court, then it can often take quite a while before we get a decision on the case.
And then do prosecutors always align with Summit County Children's Services when it comes to their argument or what they believe? Or are there times when our office disagrees with what Children's Services is asking?
I think with respect to that, it's kind of like being in the position that any attorney would have. You know, most of the time we agree that they are wanting to proceed in the right way and everything. I think it's kind of few and far between that we don't feel that we're taking the right course of action, but whenever they're not, if there is some disagreement there, either way, they're our client. So we have to still represent what Children's Services wants. We can give them advice on what we think is right or what we think is not right. But they're our clients, so we still have that ethical duty to represent their position.
Okay. Well, I appreciate the time. It is 7:25. We typically wrap up at 7:30, but of course, we always run over. So I want to make sure that Maureen Walsh joins us and does her presentation. And I don't want to rush you through it, Maureen. You do what you need to do. But if anybody as part of our Citizens Academy needs to leave at 7:30, I apologize that we're going to run over. You need to leave. If not, stick around, and Maureen will join us. Hi, Maureen. Thanks.
Hello.
If you can introduce yourself.
Hi, I don't want to rush you, but you have 5 minutes. I'm just kidding, Jake.
You got 10 minutes.
So I'm Maureen Walsh. I am the supervisor of the Juvenile Delinquency Division, and I know that I don't have my stuff up on the screen yet. So let me tell you a little bit about the divisions. First of all, you've heard from Jenny and you've heard from Katie today, and they both talk about having a passion for their job. So let me tell you, I have a passion for juvenile justice and juvenile cases. There is such a similarity between what we do and what the criminal division does, and there's such a difference. So you can go to the next screen yet, if you could, please. Let me see this. We have five attorneys over here. So what is juvenile delinquency? Juvenile delinquency refers to cases, right, which a crime was committed and the person is 18. That's semi-true. The untrue or the additional part of that is we also deal with what's called unruly cases. So those aren't crimes. An unruly case is what we call status offense, which means if you do something wrong, by virtue of you being a child, that wouldn't be wrong if you were an adult. So truancy from school is a good example. Once you're 18, you don't have to go to school. If you're under 18, you have to go to school. There's a reason for that, because it really does make a difference economically and community-wise to have people that are educated. It is one of the things that could really change a person's life, whether they have that diploma or not. So we prosecute what's called status offenses. That's an unruly offense. We also do crimes. So when you heard Jenny talking about rape and sexual assaults, let me tell you, a lot of people think that juveniles, commit juvenile crimes, but they rape people, they murder people, they shoot people. We have all of the criminal crimes that are committed as an adult, unfortunately, also are committed by children. And the majority of victims, not all, but a lot of them, are other children. So we see children dying. We see adults dying. What we see in the juvenile delinquency division is really hard. And I think it's hard to be a prosecutor within this division. We look at assaults, right? We look at aggravated robberies with regards to having a gun and pointing it at somebody and stealing things. We have those all the time. Charges are generally filed by the officers who investigate the crimes. What happens if something happens in your community, you reported it to an officer, it's against a juvenile, and they decline to give charges? In our office, we have what's called a walk-in, which means, let's say somebody committed a crime, they were a child, and you were a victim, and the police officer says we're not going to charge. You have the right to ask us to review that. We call it a walk-in, which means you have to come in with the report. You can give us a call. We'll look it over. We may agree with the officers that there's not enough evidence to charge, and then we'll decline to charge. Or we may say, no, we agree. We have enough to charge over here, and then we'll go ahead and file charges against the juvenile. So it goes from unrulies, misdemeanors, all the way up to aggravated murder. Next slide. So why do we, I see, why are they heard? So Judge Teodosio and her magistrate hear the cases. The majority of them are heard by the magistrate, even the serious cases, but the most serious case is heard by the judge herself. So if we're going to talk about bindovers in a little while, murder cases, those cases are heard by the judge. If I'm asking for a youth to go to juvenile prison, that part of it's going to be heard by a judge, not a magistrate. The court has jurisdiction up to the age of 21, but that is only for crimes that were committed before the age of 18. So she does. So if you're 21 or you're 20, you go out and commit a crime, you go to the adult court. You do not go to the juvenile court for that. Next slide. All right, so what's the purpose of having a separate court for juveniles? This is pretty important. We all know juveniles are different than adults. If you go back in your own life or you look at your own children, the thought process of juvenile is not that of an adult. We know that brain development is different. We know that kids are more impulsive. We know that they tend to follow other people. They're just different. And when you also think about it, if you had a kid that committed a crime at the age of 14, who that kid is at the age of 17 is generally a different person. Not always, but in general, who you are at 17 is not the same as who you are at 13. So treating juveniles as if they were an adult is just wrong. We look at a couple things. We look at what we can do to try to keep this juvenile from continuing on his path or ending up in prison. We also look at what is necessary for community safety or for the victim. So we have a lot of different things that go into how we prosecute people, what we seek as far as dispositional orders, and how we present cases to the judge or to the magistrate. Looking for the next slide, James. So what does the juvenile delinquency system look like? All right. So, as I said, the purpose is not only protect the community, but also is to rehabilitate the juvenile. That is part of what we do. So every case we try to figure out, what does this particular kid need so that he doesn't do this again? Here's what we know. Rehabilitation within the community is often more successful than within a system. It makes sense if you think about it. If you teach a kid to behave when they're locked up, they learn how to behave when they're locked up. But when they go back to their home, it's hard to bring the things they learned within that kind of facility back into the community. So if you can help a kid in the community and keep the community safe and teach them different ways of thinking, different ways of doing things, the odds that it's going to work are increased. We cannot always do that. And there's reasons for that. One is community safety. If a kid picks up a gun and shoots somebody, that is a kid that should not be in the community for a while. It's just too dangerous in the position of the state. So looking at those things and trying to get community safety is tricky, but it's something that we really look at in each particular case. So some of the things we might ask for is anger management. We could ask for counseling. There's what's called a peace circle that the court sometimes offers between people. There's also two other different things that if you're a parent or a parent of a child that's having difficulties, one is the Family Resource Center at the court. So if you don't know how to help your kid, you can call the Family Resource Center and they can tell you things that are out there for that particular kid. The court also has what's called the Parent Project. That's for parents that are having difficulties with their kid. And I always say that that's the one thing in court that is dedicated to parents as opposed to just to the juvenile. So it's just for parents. They can come. The people that teach that are really good and they can help you try to figure out different things that you can do. Go ahead, James. So what happens when a juvenile commits a serious crime? So I was listening to Jenny. I'm going to start with sex crimes just for a second. There's differences between what happens in the adult and what happens to the juvenile. You can never get life in prison if you're a juvenile. Okay, that's number one. We do have registration. So let's say you have a 17-year-old and you raped a 13-year-old and he's convicted over here and he stays in juvenile court. Would he have to register? Yes, it's mandatory. If you're 14 and 15, it's discretionary. The judge can say, I don't want him to register. If you register and you are convicted as a juvenile, that registration goes to the police. It is not made public. Neighbors are not notified that there's a juvenile sex offender that's living next to them. Schools, I think my understanding is, and I believe that the principal of the school will be told, hey, this kid has just been convicted of this charge. That doesn't mean the teachers are told, and certainly the other students are not told. There is a huge difference between how juveniles are treated and how adults are treated. There's a huge difference with registration. There's a whole lot of reasons why that comes into play. But other than the ones that are mandatory and even under that section, the public is not made aware. The police are aware. There is also sealing is not automatic. Expungements, it's not automatic. You turn 18 and things do not automatically get taken off of your record. You have to apply for that. There's different things that go into that. A different age, and that's going to come out a little bit later. The court always goes for least restrictive, all right? There are some mandatory things, like when a gun is used for an aggravated robbery, that's mandatory DYS time. We also have, let me look at this. There's a community control facility that's kind of a little bit below the Department of Youth Services. Department of Youth Services is a prison. Community control is not, but community control facilities are locked facilities, but they are not as stringent as the DYS is. Serious youth offender designation. Sometimes we have that. An SYO, that's what we call it. Let's say you have a felonious assault where somebody gets shot. That's not a mandatory bind over if the kid was 16 or 17. But let's say it's very serious. I get a report back and it says this kid should be kept in the juvenile system. All right. What am I going to do? It's a serious crime. I may ask for what's called an SYO. What that is I can, if successful, a kid will be designated as a serious youth offender, he will get an adult sentence. That adult sentence will be held over his head. It only goes into play if he messes up and doesn't complete his juvenile sentence. So let's say I get a kid, he ends up going to a community corrections facility. He doesn't do well, he comes out, he commits another crime, but he has what's called an SYO. I can petition the court to impose the serious youth offender so that he gets the adult sentence. So it's kind of a bifurcated thing, and we use it so that kids that have done something very, very serious that would warrant, in my opinion, perhaps going to a prison, but we want to at least give them a shot at making it through juvenile and turning his life around. We hold that SYO over his head, but we have to ask permission for that to be imposed. Okay. That's just what I was talking about, the SYO. Okay, so it's the adult sentence suspended. If he's not successful, I'm going to tell you with SYOs, it is rare for SYOs to be imposed, but it is not unheard of. Okay. SYOs also, if I'm going for that, it's the only time they get a jury trial. Everything else is just in front of the magistrate or the judge. Go ahead, James. I hope I'm not rushing too fast. Bindovers. Bindovers are important. There are some offenses that are mandatory if you are 16 and 17. If you are 14, 15, 13, it is never mandatory. If I think that a 14-year-old, let's say a 14-year-old commits a murder, and yes, we have those, I can ask the court to transfer the case to the adult division, but I have two hearings. The first one, I have to show that this kid is likely to have done this. The second hearing, I would have to show that he is not amenable to the juvenile justice system, meaning there's not enough time and the court could not successfully rehabilitate him. There are different factors that go into that, but that is a hearing. We generally have a psychologist, we get records, we put on one way or the other whether or not the kid is going to be amenable or not to the juvenile justice system. Generally, if the court, let's say you're 14 and you commit a murder and the court found that he should stay within the juvenile justice system, or she, generally that child stays until right before the age of 21 in the Department of Youth Services. However, there are other cases like aggravated robberies that generally they do not stay to the 21. They go to the Department of Youth Services for maybe 6 to 9 months. If there's a gun involved, they go for 2 years, but then they're let out. Bindovers, mandatory is 16, 17. They're generally for murders, for aggravated robberies with a gun. They are not for rapes. If I thought a kid should go over because of a rape, I would have to file and I would have to prove that that child was not amenable. Rapes and murders are the only two crimes within the juvenile system that does not get taken off of a person's record. That doesn't mean you can go and easily find out that that juvenile has that record. You know, Katie mentioned to you about getting into that within the juvenile system. And just like what Katie said, you can come and you can go to a hearing if you want. Those are open hearings. It's hard to figure out what hearings are going on, however. Okay, James? That goes through about the discretionary or mandatory with regards to bindovers. Go ahead, James. Specialty dockets. So juvenile court has specialty dockets. Every one of these has a prosecutor that's dedicated to that. Restore court is our court for human trafficking. Human trafficking and restore is interesting, I think. If a person, a girl or a boy, is at high risk of being either labor trafficked or trafficked in the traditional sense that we think of, like prostitution, high risk can get you into restore court. So like if you have a kid that's constantly running away, and let's say it's a girl and you know she's spending lots and lots of hours with adult males, she's a good candidate for restore court. If a child is a victim of human trafficking or labor trafficking, and that crime is related to their victimization, that is automatically diverted. I shouldn't say automatically, after hearing if those things are proven. That's for any crime, including a murder. Okay, so Restore Court is a pretty important court. Crossroads is our mental health and drug court. We have a traffic court. BHJJ is generally for high-risk kids. That provides in-home counseling. They have a caseworker. It's one of our best specialty dockets. New PATS is for cognitively or developmentally delayed children that come within our system. You know, all children are subject to juvenile court, but it is a criminal court. So you have to be competent in order to have criminal charges against you. Generally under the age of 12, we look very serious before any charges are filed against a youth under the age of 12. 10 is the age when people are presumed to be competent. Anything under 10, there's almost a presumption that they're not competent. So most people are going to be hesitant, including myself, to file charges on anyone below the age of 10. All right. And below the age of 12, we do it very hesitantly. Jenny told you about rape under the age of 13 is rape. You cannot consent to that. You have 2 kids under the age of 13 that are engaging in what you would think of as consensual. You cannot, because there's no consent, but you also can't charge 2 kids under that age. The only way that would be charged is if somebody was using force or threat of force. So if you have a 12-year-old that's committing acts on a 3-year-old, we would have to show that force was involved in order to bring charges against that child. Go ahead, James. Sealing and expungement, like I said, it's not automatic for anyone. So if you turn 18, you can apply. You have to show that you completed all court orders, that you've been rehabilitated. We take a look at those. We try to call someone in for contact the victims to see if they have an opinion on that. And then we go to court. Sometimes we say, it looks like that's a good sealing. We have no opposition. Sometimes we oppose. Ultimately, it's up to the court. Like I said, aggravated murder, murder, and rape are not eligible for sealing. So they stay on a person's record forever. Last thoughts, let's see. Yeah, you know what? There is not a lot of media coverage with regards to juveniles. And there are many ways that is exactly how it should be, because not all of us want the things that we did as kids exposed. The other side of that is, you know, things such as the fact that, I don't know if you're aware, but in the United States right now, the leading cause of death of children is firearms. Think about that. It's not cancer. It's not automobile accidents. It's not other things. It's firearms. We see gun-related offenses every day. I don't think a week go by that we don't have someone charged with an extremely serious crime, and our children are dying or they're killing people. And sometimes I think that a lot of people really don't know how serious things are right now that are going on in Summit County and that are affecting our kids. We have cases with kids bringing guns to school. We have assaults that take place in school. We have threats with regards to school. You know, we do our absolute best. I always say, if you see something, say something. If you hear something, say something. You know, kids have a right to feel safe. I would say most of our juvenile offenders, people who commit crimes, have a trauma history. You know, something has happened to them. They have seen things. They have heard things. They don't, you know, the people aren't born into going out and shooting somebody. Part of the job as a prosecutor is to try to figure out what's going on, to see if we can lend a hand in any way to bring that around, while seeing to the needs of the victim. You know, if you are a victim at the age of 7 or 12 or 14, that stays with you. You know, we represent victims in court and make sure that their voices are heard. So in addition to the 5 prosecutors we also have a victim advocate and a victim coordinator whose job it is to make sure that families and juveniles that have been victimized, voices are heard in court. That is one of my main jobs, to help to protect victims and to help to ensure community safety. Part of ensuring community safety is trying to craft dispositional orders that allow for the rehabilitation of our youth so that they can go on to become productive members of our community. and that they're not harming anyone. That's so important on every level. You know, prosecutors are not against juveniles that are charged in a classic sense of the word. I don't want to see people end up going to prison. So I try to craft something so they don't get to that next step, so that they're not a victim of crime. I cannot tell you the number of murder victims where just a week or a month or 2 months before, they were sitting as juvenile defendants. It is heartbreaking to see that happen. So we advocate on behalf of victims, and we try to help make the community safe. Okay, so now I'm ready for questions.
We do have a couple of questions that popped up into the chat. One is, how do you find out about hearing dates at juvenile court? I'm guessing if you're not involved with a specific case, is that right, Renee? It's just in general, how do you find out about it? I don't know if Renee's still here. But anyway, Maureen.
Hi, yes,
Oh,
I'm
there-
sorry, I am
That's okay.
still here. And it is someone that used to live with me. So I'm not directly involved, but I'm indirectly involved.
So, you know, the definition of a victim who's entitled to get information or that we help to get is really broad now constitutionally. So if you've been affected by a crime in some ways, you know, and you're a victim of a crime, so let's say your child is hurt, certainly the parents, certainly the grandparents, certainly an aunt or an uncle can all kind of fall under that umbrella. I know that we in the prosecutor's office will make sure that victims and families are notified. If you are not, I'm not quite certain of that. You know, you could call the court and ask for a court date. They may or may not give that to you. That is probably the first I would try, is to call the clerk of courts to see if they can give you a date. If you are related to the juvenile that is charged in a crime, I would go through that attorney. Does that make sense? So I
Yes,
don't
it
know.
does.
Okay.
Yes, thank you. I'll call tomorrow and see what they advise.
Okay.
Yes, thank you.
You're welcome.
Thanks, Renee. Thanks, Maureen. That was the only question in the chat. I know it is now 7:49, 7:50, so obviously we're over. I appreciate everybody's sticking around. Maureen, thank you for going through your presentation. I apologize for not having enough
I
time.
hope it wasn't, I hope it wasn't too quick. Let me say this. I think we're the most important division in the office because we do the kids. And I guess every person probably says that. So when you get to hear the gun violence, know that I could be sitting right next to them and adding to that, you know, but I say we are the court of hope, but we are also the court of sadness because, you know, there's nothing like seeing juvenile victims that have been hurt. Sometimes seriously. So, you know, we are the future. We help to shape it in some ways and protect it in others. So thanks for letting me talk, James. The last
Nope.
one.
Thanks, Maureen. Thank you for doing that. And I appreciate it. Katie, again, thank you for your presentation.
Thank
Thanks
you.
everyone for joining us. Hopefully next week we'll be able to get out on time, but I don't guarantee that. So again, thanks so much, everybody. I really appreciate you taking the time out and sticking around late. And if you have any questions, again, if there are any other questions that pop in, or if you have any other concerns, Tanya and myself, if you email us, we'll be happy to pass it along and try to get you in. So again, thanks so much. We'll see you guys next Wednesday.